and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hello and welcome to another episode of Unpacking the Case. Recently, we hosted a webinar on adverse possession, and as often happens, the audience had far more questions than we could answer live on air, and it's not hard to see why. Adverse possession sits at the crossroads of boundary disputes, historical land use, and occasionally neighbourly disagreements that have been brewing for decades. So what seems like a straightforward question can quickly become anything but. So, in today's episode, we're tackling the questions we didn't have time to answer. We'll be exploring everything from proving possession and gathering evidence to disputes over boundaries, rights of way, public land, landlord and tenants issues, and much, much more. Joining me, as always, is our head of legal training, Richard Snape, who'll be helping us unpack some of the most common and some of the most surprising questions submitted by our audience. So, whether you're dealing with an active dispute or simply want to understand how these claims work, this episode should provide some useful tips. Let's get started. Hello, Richard.
Hello, Lizzie.
We're back with another episode of Unpacking the Case, and we ran a webinar on adverse possession recently, which attracted a huge audience and probably unsurprisingly generated far more questions than we could answer during the live session, which seems to be the case more often than not these days. Adverse possession remains one of the most misunderstood areas of property law. And whilst the legal principles are well established, the practical scenarios can be anything but straightforward. So in this episode, we're working through some of the most interesting questions submitted by our audience. And as always, this is intended to be a general overview rather than legal advice, but hopefully it will be good guidance if you're dealing with adverse possession issues. So let's get started with the first set of questions, which are kind of the fundamentals to adverse possession. So one member of the audience asked, what demonstrates possession?
Well, it's got to be a factual possession, corpus possessionis, and an intention to possess, animus possidendi. Basically, you're treating the land in the same way as if it was your own land. You don't have to think it's your land. And you intend to exclude all others, including the paper owner. But as you said, it depends so much on the facts. I mean, a lot of the cases are just, sort of expert reports and this kind of thing. And, they depend on this, they get different decisions on the slightest of grounds, really. But yeah.
And could factual and intentional possession both be demonstrated through maintenance?
Yeah, we've had that recent case that we did a podcast on, and I mentioned in the course, Dobson and Unstead, where there was no fencing or anything like that, but a series of small activities like sort of mowing the lawns of this corner of a garden, and planting flowers and bulbs there, and like some kids playing, your kids playing on the land, all that sort of constituted on the facts adverse possession. That's not to say every time it will do so, but it's certainly a factor.
What is the difference between encroachment and adverse possession?
Well, that's a topic in its own right. The law going back to medieval times on it. We had that the case on it that we talked about, but it's not the only one. The McGee and long-term reversions Harrogate, which actually took place in London, somewhere around Wimbledon. If it's encroachment, this was the one where there was an attic space. They had a top floor flat, and the attic space was still entitled to the landlord. But they encroached. From claims nowadays, they basically sort of put steps up to the attic and the power supply, even though they knew it wasn't theirs. For post-2003 adverse possession claims, if they are defended, you have to show one or more than three types of adverse possession, most notably that you've made a reasonable mistake as to boundaries. And they obviously didn't make a reasonable mistake. They knew it wasn't their attic. But the tribunal decided you could still claim encroachment, but it didn't have to be a reasonable mistake. It was a case called HUD and Southern Land Securities this year as well that said the same thing about an attic space, or last year. And also there's a case called Rellins and Gill, which they successfully claimed encroachment of a roof terrace. But there are cases galore, lots of cases in the 19th century of it. It's more akin to an estoppel claim than an adverse possession claim. But that McGee case, I think tribunal said that, we've got the judiciary's got themselves into a huge tangled web in between the two. But yeah.
And is adverse possession still possible if the claimant has granted licenses to others and received rent?
Yeah. Strangely, that's something that sort of points strongly towards adverse possession. Again, if it's a post-2003 land registration claim, it would be different. But there was a case called Moore and Doherty, which is granting licenses was evidence that you're adversely possessing the land. And there was a case I didn't mention called Mitchell and Watkinson, which was granting a lease to somebody even though you didn't know the land, own the land. And that's a strong pointer to adverse possession.
And can you adversely possess land which is subject to rights enjoyed by others?
Yeah. I mean, if you adversely possess against somebody, but it doesn't destroy, certainly in registered land, it doesn't destroy other people's rights over the land, like somebody might have an easement over the land that you've adversely possessed, or a charge for that matter.
And can different owners' periods of occupation be aggregated to make up the qualifying period?
Yeah, as long as there's not a big gap. But it's quite frequently the case that you'll have a sort of shifting population. There was that Vodafone potting sheds and bar and gardens, which said that you have to have the same type of estate in land. Leaseholder can't continue adverse possession vis-a-vis when the predecessor was a freeholder, let's say. And that's perhaps a proviso, but yeah, definitely.
So moving on to registered land, what happens if the Land Registry cannot locate the owner?
Well, if the title is registered and you claim adverse possession against the paper owner, they should be able to locate them. If they can't contact them, the Land Registry will have records of the paper owner if the title is registered. If they can't contact them, if it's a first registration application, but if they can't contact them themselves, there's always a possibility you can actually fill in something called an ADV2, which allows a third party to be notified that there's an adverse possession claim if you're living abroad or something like that. But that's a possibility, yeah.
And how relevant is the general boundaries rule where land is included in a neighbour's title?
Yeah, basically, like the Clapham and Naga case we mentioned, you can always apply to the Land Registry to have the boundaries exactly determined. But the Land Registry, the filed plan and the description, don't definitely determine the boundaries. They're just evidence of where the boundaries are. So if it shows up as in the neighbour's title, it doesn't stop the general boundaries rule still applying. You mentioned the case Drake and Fripp, where it was something like 4 or 5 meters out was where the plans showed the boundary to be from where they were actually determined to be. And you can look at various other evidence to determine the boundaries.
Do both parties have to agree to a determined boundary?
If you've applied to determine the boundaries under the land registration rules, then the person, you're against, your neighbour, if you like, for want of a better expression, will be notified, and they've got 28 days to object. And if they don't, and you've given enough evidence for the Land Registry to determine the boundary, then that's what they will do. So otherwise, they have to agree. If they object, then there can't be a determination.
Why are determined boundary applications often unsuccessful?
Well, you've got to produce evidence of what the boundary is, and that's where the other side has to either agree or in default by not doing anything. And just because you've applied to determine the boundary and the other side doesn't respond, doesn't mean to say you've produced enough evidence for the Land Registry to actually successfully determine the boundary.
So moving on to leaseholds, can a tenant obtain adverse possession of a landlord's adjoining land?
Well, this is where we come back to encroachment and the likes. And it's like an estoppel claim. You can actually sort of potentially claim encroachment. The difficulty was there was a Hong Kong case, but an appeal case with quite high-profile judges called Secretary of Justice for Justice and Chow Kar Chit So back in 2011. which basically cast doubt on encroachment and the likes, but the recent UK cases have said otherwise. You can only claim encroachment for the duration of your lease, if you like. It'll go back to the landlords afterwards. But you can claim adverse possession. There have been cases where you've claimed adverse possession, for instance, against just sort of an intermediate landlord. And it will, and the likes, that's a possibility, yeah, definitely.
Would a successful attic claim create a flying freehold or a leasehold title?
It's, again, if it's an encroachment you're claiming, then basically it sort of just adds to the leasehold, if you like. And when the lease comes to an end, it reverts back to the landlord. Obviously, if it's a 999-year lease, not for a long, long time, but yeah.
Okay, thank you. So moving on to rights of way and public land, can access rights be extinguished through non-use?
Well, that's sort of not so much adverse possession or extinguishing easements. It would be very, very difficult to show that. I mean, there are cases galore over the years. Remember, there's one called Dyer in Westminster City Council, or Dwyer, not as in Danny Dyer, which basically said that after 40 years of non-use and passageway being blocked up and the easement hadn't been extinguished, and there was Ben and Harding, which was they didn't accept an easement to be extinguished after 175 years non-use. The best way of extinguishing rights of way is by surrender, preferably by deed, an express deed of surrender. And that's probably the one the Land Registry will accept only.
And can land that's used primarily for access be adversely possessed?
There was a case called George Wimpey and Son, which I don't think I mentioned in the course, in 1967, which basically said if it's just access and that's it, that's not adverse possession, that's not intending to possess and factually possessing the land.
And what should public bodies do to protect land?
Pretty much the same as private bodies, quite honestly. And that's just, again, if the title's registered, and one of the reasons they changed the law in 2003, but not retrospectively for registered land, it was to encourage first registrations, voluntary first registrations for things like public land in particular, because some public bodies, and particular central government, are massive landowners. And the best way of protecting is getting the title registered, because then, unless there's person making the application has got a actual boundary, and there's a reasonable mistake as to boundaries, they are likely to fail and also police the land. But it's no different between public and private bodies.
Can a unilateral licence prevent a future claim?
If you're given a licence, just like if you're given a lease, it can't be adverse possession because you've got permission to be onto the land. If you stop exercising the licence, as in Pye and Graham, where they were given a licence to be on the land and they grazing rights and they were paying money for it, and they just stopped paying the money from that moment onwards, then the adverse possession claim can start.
Okay, moving on to some quick fire questions to finish. What happens to charges and mortgages?
Basically, if it's registered land, 2003 onwards claims, it's Schedule 6, Paragraph 9, subparagraphs 2, 3, 4. They'll remain in existence. It's a bit twisted the way it deals with it. What they basically say, the charges will remain if you make a claim under paragraph 5, which is things like reasonable mistake as to boundaries and the likes. If it was unregistered land, then the charge would remain as long as within the 12-year time period the mortgagee had taken steps to enforce, demanded the money and the likes. But if the person who's subject to the adverse possession claim hadn't paid the mortgage for 12 years and the mortgagee didn't do anything about it, then the mortgage would die.
Does adverse possession exist in Thorpe and Frank?
Yeah, Thorpe and Frank was this one where they had a couple of semi-detached properties in York open plan. And they, was restrictive covenants against putting up fencing. And in that particular case, they said that adverse possession existed and you don't need fencing for adverse possession. There's been that Kirkman and Bradshaw Pub Company last year that said the same, and this year Dobson and Unstead said the same thing. If there's good reasons for not fencing, you don't have to fence.
And what about in the Pye case? Did Pye object within the 65-day period?
Pye and Graham was a pre-Land Registration Act 2002 claim. The facts went back to the early mid-1980s. And so you didn't have to object within the 65-day period in that particular case.
Can you claim adverse possession of unregistered land if you know it's not yours?
If it's unregistered land, yeah, you can claim. You don't have to think it's your land. You might know it's not your land. You might know that one day the paper owner's intending to throw you out, but you can still claim an adverse possession, different for post-2003 registered land claims.
Thank you very much, Richard. Thank you to everybody who attended the webinar and submitted questions. As this has demonstrated, these things come up frequently in practice. So yeah, lots of questions to answer. If you enjoyed the episode, please do subscribe to Unpacking the Case. We regularly explore real estate legal issues affecting property professionals across the sector. And hopefully we'll also see you at one of our future webinars. But thank you very much, Richard.
Thanks a lot, Lizzie, and see you again.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.